The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good morning. We have 3 cases that will be submitted this morning. Those cases are Planned Parenthood of the Heartland and Jill Meadows versus Kimberly K. Reynolds and the Iowa Board of Medicine. The second case is Joanne Coate versus Derby Insurance Agency. And the final case is Ray J. Cracklio versus Kent Simmons. Now, that last case is now submitted to the court without oral argument, and we'll proceed to hear the arguments in the Planned Parenthood case. Ms. Chapman.
May it please the court, counsel. This case concerns an abortion restriction that the district court acknowledged is one of the most severe restrictions in the country. Specifically, this restriction would force Iowa women seeking an abortion, regardless of their individual circumstances or how certain they are in their decision, to make a medically unnecessary trip to the clinic, then turn around, go home, and wait at least 72 hours before returning for the procedure. The district court found that these requirements would significantly burden and harm thousands of Iowa women each year, but held that those burdens didn't amount to a constitutional violation. That conclusion rested on 2 legal errors that I would like to address in turn. First, the court's failure to apply the proper standard under the Iowa Constitution for enforcing and protecting a fundamental right. And second, after the district court adopted the federal undue burden standard, the district court's failure to properly apply that standard as a balancing test. This court, again and again, has placed the values of liberty and equality and the rights of the individual at the center of its analysis of the Iowa Constitution, from equal protection cases like Varnum and Gartner to due process challenges such as Calendars versus Skiles.
The first question I have is the purpose of this law to advance fetal life, or is it further the health or interest of a woman seeking to terminate her pregnancy?
The state has never asserted that the purpose is to further the health of the woman seeking to terminate her pregnancy. So,
does the undue burden test come in when you deal with the interest to advance fetal life? I mean, when you read Casey, the undue burden part is not really on that prong of the test.
The U.S. Supreme Court has provided further clarification since Casey in Whole Woman's Health that this balancing test, the undue burden standard that Casey announces, is a single balancing test applied regardless of state interest. And that's, in Whole Woman's Health, the U.S. Supreme Court described Casey as applying a balancing test to a range of state interests, including the interest in protecting potential life. And that's how the lower federal courts have been applying Whole Woman's Health. They have rejected any argument that the balancing test doesn't apply when the state asserts an interest in potential life.
You noted that Iowa's 72 hours is one of the most restrictive in the country. Would it be a different analysis if the legislature here had chosen a 24-hour waiting period?
It would, Your Honor, under the federal undue burden standard, not under the strict scrutiny standard, but under the federal undue burden standard, as this court has recognized, that is a highly context-specific standard, and so the analysis is always different depending on the specifics of the state law, and in this case, the level of delay that the state mandates.
Would a 24-hour waiting period be constitutional in Planned Parenthood's view?
We don't believe so, because the evidence demonstrates that women take the time that they need to make these decisions, and it's completely unnecessary for the state to impose a mandatory delay on women, and it's burdensome, especially when the state requires an extra trip. So some of those mandatory delay laws require an extra trip, and some don't. Some allow the information to be conveyed, for example, by telephone. And so the evidence is clear that the extra trip requirement and any mandatory delay is burdensome and doesn't serve a valid purpose.
And so it'd be, should the 24-hour and 72-hour waiting periods meet the same fate in your view? Because even the 24-hour would require 2 trips, right?
In our view, yes. However, in the application of the undue burden standard, the evidence would be different about the burdens imposed.
Okay, but the Casey court did uphold the 24-hour Pennsylvania waiting period, right?
That's correct.
Do you acknowledge that at least some women of approximately 4,000 that undergo abortions in Iowa a year, that at least some of those women might change their mind if they had access to additional information and a 72-hour time to reflect?
We don't acknowledge that, Your Honor, because the evidence is that women take time before they make their appointment, and they don't need a state-imposed mandatory delay.
What about the Utah study that showed 8%, which in Iowa would be 320, that those women did change their mind?
So the study didn't show that 8% changed their mind. The study showed that 2% changed their mind. 8% continued their pregnancy, but that included women who came to the first visit inclined to continue their pregnancy. The evidence in the record is that some women come to an appointment either inclined to continue their pregnancy or simply exploring their options. So that 8% included women who were inclined to continue their pregnancy. It also included women who continued their pregnancy not because they changed their mind, but because they were prevented from having an abortion by costs or logistical burdens. And so what that study showed is that it's really only 2% who changed their mind, and that's in the same range as the percentage of patients who changed their mind in states without a waiting period law. So that study really shows that these laws don't change patients' minds.
Can you tell me why Iowa should adopt a strict scrutiny under the Iowa Constitution?
Yes. So this court has not hesitated to apply the Iowa Constitution independently of federal courts applying analogous federal protections when the values of liberty and equality are at stake, and to give value and full scope to those values of liberty and equality. And these same values are also deeply at stake when, as here, the state acts to limit a woman's ability to decide whether or not to bear a child. Indeed, both federal courts and numerous state courts have recognized how fundamental that interest is and have recognized that women have a fundamental right to end an unwanted pregnancy. Specifically, they've recognized the enormous physical, medical, emotional, and practical consequences of a woman being forced to—
Many states that do that, though, have different constitutional provisions. I think Montana has a special privacy one, and it's a little different than Iowa. I mean, are there states that still apply strict scrutiny without those different provisions?
Yes, so we've pointed the court to at least 12 state high courts that have accorded greater protection to the right to end an unwanted pregnancy than the federal standard. And of those 12, actually the overwhelming majority don't rely on an express constitutional right to privacy in their state constitution. And also of those courts, 2 state courts in West Virginia and New Jersey, I want to highlight their decisions because they base their conclusion in part on constitutional language in their state constitutions that the Iowa Constitution also contains. And that's Article 1, Section 1 of the Iowa Constitution, which declares all men and women free and equal by nature, and guarantees to them inalienable rights to liberty, safety, and happiness. And that's exactly the language that the high courts in New Jersey and West Virginia cited to in finding—
Ms. Chapman, if this court adopted a strict scrutiny standard under the Iowa Constitution, could you give me an example of a restriction on abortion that could constitutionally be imposed?
Sure, Justice Mansfield. States that have a strict scrutiny standard still do have ordinary health and safety abortion regulations.
Could you make an abortion illegal outside of to preserve the life of the mother, or in other special circumstances? Could you make it illegal, say in the 7th or 8th month of the pregnancy?
Certainly, the federal, in Roe v. Wade, the court recognized that abortion was a fundamental right and that the state's interest in potential life does not become compelling until viability. So there's certainly a distinction before viability and after viability. And here we are only talking about abortions that occur before viability because Iowa has an independent 20-week ban, which is well before
So
viability.
in your view, after viability, the state could prohibit abortion even under a strict scrutiny standard. Is that correct?
Correct, with proper protections for the health of the woman.
Well, aren't we also only talking about the state's desire to ensure that women are making this decision in a thoughtful and an informed way? Isn't that what this restriction is about?
I think this restriction is not about that. I think this restriction is about the state's desire to change a woman's mind, because the evidence in the record demonstrates that women make these decisions in an informed and thoughtful way. They gather information before they even go to the first appointment. At the appointment, there's an extensive counseling and patient education process. There is no evidence anywhere, and I didn't see any in the legislative record, that there is information that women are not getting before they make their decision. So to return to the question about whether this court should recognize a fundamental right to abortion protected through strict scrutiny, as federal and state courts have recognized, not only are there serious consequences to a woman who is forced to carry an unwanted pregnancy to term, but to quote Casey, there are few decisions that a person can make in a lifetime that are more intimate and personal, and few decisions that are as central to personal dignity. And finally, courts have recognized that women cannot be truly in control of their own lives and participate in society as equals unless they are able to have control over their own reproduction.
Does it undercut your position that we should recognize a fundamental right to abortion under the Iowa Constitution when, in our state, abortion was a felony at the time the Constitution was ratified in 1857 and remained a crime up until Roe v. Wade created a federal right?
No, Justice Waterman. This court has recognized again and again its responsibility to protect individual rights, even when, in the language of Varnum, even when the rights have not yet been broadly accepted or were at some time unimagined. And as this court recognized in Callender versus Skiles, due process protection should not ultimately hinge upon whether the right sought to be recognized has been historically afforded, because the Iowa Constitution recognizes the changing nature of society. And indeed, federal and state courts alike have recognized and afforded protection for rights that were not historically recognized, not just in the area of abortion, but contraception, same-sex marriage, and other similar rights. And this is certainly one of those cases where the changing nature of society is on full display, because until recently, it was unimagined that women would want and be entitled to social roles other than motherhood, and to be able to participate equally in the economic and social life of the country. Just as a historic footnote, respondents aren't correct that abortion was entirely illegal at the time that the Constitution was adopted. It was illegal after quickening, but it was legal through quickening, which occurs at about, can occur at about 16 weeks of pregnancy, which is later than the overwhelming majority of the abortions that we're talking about in this case.
Help me with the undue burden test if we were to go that route. And I'm not sure I understand it fully. And indeed, in its application in the federal case law, it seems challenging. The cases are splintered all over the place on the same type of restriction. And I understand it's a balancing test, and I understand the phrase is undue burden. But what I don't understand is what its spine is and how we can apply it without ending up with a kind of a tis-taint argument. Can you help me provide a little more doctrine to an undue burden test that would assist the court in applying it?
Sure. So in addition to being a balancing test, I think what the U.S. Supreme Court clarified in Whole Woman's Health is that this is evidence-based on both sides of the scale, and that it's the state's burden of demonstrating an actual benefit sufficient to offset the harms that the law would impose. And the court also made clear that this is not some form of rational basis review because, as the court reiterated, a constitutionally protected liberty interest is at stake. So one of the principles is that the balancing test has to protect and give real protection, in the language of Casey, to a constitutionally protected liberty interest. So not only does the state bear a burden.
I don't read Casey as engaging in balancing before sustaining the 24-hour waiting period. Is there language there that I'm missing?
I don't know that there's language that you're missing. I think that Casey has to be read now in light of Whole Woman's Health and the way that that case reads Casey.
Your view is that language that's sort of the parenthetical characterizations in Whole Women's Health kind of overturned that portion of Casey. Is that right?
Added clarification and definition to Casey that may not have been in the original decision. And I think also, to continue answering your question, Justice Apple, what the court clarifies in Whole Woman's Health is that this is a test that considers the full range of harms that an abortion restriction causes. And it's not focused on whether or not women are prevented from having an abortion altogether. Indeed, this court anticipated the balancing test in Planned Parenthood 1, the telemedicine abortion case, when it struck down a ban on telemedicine abortion under the Iowa Constitution on the ground that the ban was factually unsupported and would cause women far more harm than any conceivable benefit. The same is true here, based on the facts established at trial. And to briefly review the burdens that we demonstrated at trial, the act would cause extensive delays, further than the delays that were cited in Casey. Casey talked about delays going up to 2 weeks. Here, the record shows that those can go on for 3 weeks or longer, and that women will be prevented. Increased medical risk, loss of the medication abortion option, and that's also a very key difference from the record, the factual record before the court in Casey. Medication abortion was not available, safe legal medication abortion was not available at the time Casey was decided. Now it is, and there's case law recognizing the importance to women, both medically and personally, of having a non-surgical abortion option. And the record demonstrated that hundreds of Iowa women each year would be prevented by this act, would be pushed past the window in which they can have a medication abortion, which in turn will force some of those women to travel much further to get to a clinic that provides surgical care. Loss of privacy, increased costs, financial strain, economic and extreme stress for many women. And I think it's also critical to note that what this act does is, respondents refer to it as an informed choice, I think, provision. It really actually undermines core principles of informed consent, and that was evidence that was presented at trial and is underscored by both the bioethicist amicus brief submitted in this case and the brief submitted by the American College of Obstetricians and Gynecologists. It imposes medically unnecessary restrictions over women's clearly stated strong preferences and needs. One study in Iowa that's in the record found that 94% of abortion patients stated it was very important to them to receive care as soon as possible. And evidence from other states also in the record shows that these laws actually drive women to seek medical care out of state. So what this act does is really violate the principle of patient autonomy that is the very foundation of informed consent. I also think that it's important to, I see that I'm actually past my time, so are there any more questions?
Well, I did have one question, and then I'll let you, allow you to sum up. If we find that the restriction under this statute would deny one woman of her constitutional right to an abortion, are we required to find this statute unconstitutional?
I don't think this case presents that issue or that dilemma because this case,
This is a facial challenge, is it not?
It is, but the record in this case shows that this law will impose substantial burdens on, most of the thousands of Iowa women who seek an abortion each year. So, the medication abortion issue that I raised, where some women are not going to be able to avoid surgery because of this act, we're talking about hundreds of women every year. Domestic violence victims who are going to have a very hard time making a second trip and may be prevented from leaving an abusive relationship because of this act, that is also hundreds of Iowa women every year. So I don't think that this case actually requires this court to draw that kind of difficult line about how many women have to be burdened to facially invalidate the act.
Thank you. You may sum up.
I'll save my summing up for I have 5 minutes on rebuttal? Okay, thank you.
Mr. Thompson.
Thank you, Your Honor. May it please the court, counsel. As Chief Justice just pointed out, this is a facial challenge. It's a pre-enforcement facial challenge of an act of the Iowa legislature. Planned Parenthood brought this action under Iowa law, under the Iowa Constitution, yet is urging you to ignore two important constitutional principles that you apply in your constitutional decision-making. The first relates to facial challenges. The second relates to what this court has determined in the past as being a fundamental right. To answer your question, Chief Justice, the answer is no. That the standard for a facial challenge is well established, and it's a heavy burden, as this court has said, as you have said, that a party making a facial challenge bears a heavy burden and must show no conceivable set of circumstances that exist under which the statute would be valid. So it's the opposite. In other words, not only if they showed one woman who was denied access to an abortion, which here is the standard, that's the right, access
But is
to choose.
that test conceivable, really a rational basis test rather than the undue burden test?
Say that again, I'm sorry.
Isn't a conceivable really a strict rational basis test rather than an undue burden test, or if we adopted strict scrutiny, a strict scrutiny test?
Well, I think it's a two-part analysis. I think that and this court has applied before in substantive due process claims the step of first recognizing that the framework for a facial challenge is different. And if you look at Gonzalez, frankly, in the federal framework, it talks about the same thing, that it's a burden issue, it's an issue about what needs to be, and then you go on to
in our past Planned Parenthood case, the district court applied that conceivable test, and we dismissed it, and we applied an undue burden test and didn't even talk about that conceivable part of it.
Well, because again, Iowa law is clear about the standard for a facial challenge. Federal law used to be clear, but as Gonzalez points out, in the abortion arena, the federal courts have created a hybrid, that the Casey standard is in fact an exception to the facial challenge requirement of any set of circumstances. And Gonzalez points out that that's a tension, but then found the statute survived notwithstanding.
So do we apply Iowa constitutional principles to a federal constitutional claim when we're applying whole health or Casey?
Well,
that's the, I think you're mixing apples and oranges.
Well, no, I think Planned Parenthood is mixing apples and oranges. And so they have asked you to apply Iowa law. And our brief has made clear that if you apply Iowa law, you follow your principles on facial challenges. Under that standard, they lose on the record that was made in this case.
Even if we would adopt the strict scrutiny, they lose?
Yes, I believe so.
And why is that?
Because it's a facial challenge, Your Honor. In other words, the difference is significant about what they have to prove. Now, in an as-applied challenge, as Chief Justice Katie points out, there might be some women who are denied the right to make this ultimate choice, but there is Only evidence in the record is that some women might, and under your standard for facial challenges, that would fail on a facial challenge. It would.
Well, the strict scrutiny will allow us to examine a little more carefully whether or not the state's objective in the restriction that they oppose is being achieved. And isn't that essential when we're talking about the right at stake?
I think, again, so 2 steps, Your Honor. Facial challenge, you first have to declare that the right to choose an abortion is a fundamental right under the Iowa Constitution to get to strict scrutiny. And I want to talk about that because it's clearly not, objectively established in the history and tradition of Iowa. But let's assume you go there. I mean, you can look to your case in Hernandez-Lopez. You can look to the Hensler case. You can look to the McQuiston case of how you then, even when a fundamental right is applied, that you don't automatically jump to strict scrutiny. First, you look about whether the statutory provision on its face actually infringes on the right. That's the trigger. And here, this is a waiting period. It doesn't say you don't get to decide. It doesn't say somebody else gets to decide. So on its face, this statute doesn't infringe upon the right. But even if it does, if you look at those cases, Your Honor, in the context of a fundamental right, this court has said, in Hernandez-Lopez, you wrote, where the government interest is sufficiently weighty, individuals' fundamental liberty interests may be subordinated to the greater needs of society. Justice Wiggins, you said essentially the same thing in Hensler.
Well, I don't think anyone's questioning the government's interest. There's a lot of weighty issues here. But really, aren't we talking about whether the restriction that's being imposed is tailored in a way that it's going to justify the restriction being that the state desires?
Well, and again,
where's the evidence of that?
Well, again, strict scrutiny, we don't have to have the most narrowly tailored. In other words, the means don't have to be the narrowest. But the evidence is, I think we were talking about the record before, is if you look at the district court decision, the court found and made a fact finding that is entitled to deference here that this did not prevent women from exercising their right to choose, and it found that the evidence in this record supported that it could change minds that in a significant number of women. And so I think...
But it didn't, I mean, don't we have to acknowledge that the district court was interpreting that study in a way that the court grouped all women who ended up not getting an abortion into one class of women, and that there were all sorts of tiers in there, that there were women that came in being very unsure about the whole process, and there were women that came in thinking they weren't going to follow through. But there was really just a small number, 8 or 9 women in this large study, that came in with the idea that I want an abortion, and then changed their mind after going through all of the informational process. So didn't the court misread that study?
Not at all, Your Honor, and let me address it in 2 ways. Number one, I want to go back to the theme. One of the problems with facial challenges is you're dealing with I think in War Eagle, this court said speculative facts, but certainly hypotheticals. We're dealing with hypothetical people. We're trying to predict what will happen. So by definition now, we're letting the plaintiff make a record about what they think is going to happen, and we're looking to state studies from other states. We have zero evidence, and you saw in my cross-examination, I asked every expert, do you have any evidence of any Iowan who has been denied or burdened in any way by the statute? The answer is no. So now we're in Utah, right? And that's what this study is about. But when you look, I think the judge got it exactly right. If you look at the Utah study and the Los Angeles study that Grossman testified about, they talk about all the people that were certain. The people that were not certain in Utah was 29%. It's not just the 8%, it's the people that said, I don't know, right? In LA, 15% not certain. Utah is the only study known where they actually asked people why they didn't come back. We got some concessions about Mississippi and other states where Grossman even acknowledged that when people didn't come back, it could be because they changed their mind. But in Utah, they interviewed people, and that 8% is specific to people who said, I couldn't go through with it.
But the restriction here is, we're really talking about the 72-hour restriction.
Yes, Your Honor, we are.
And we're not necessarily talking about the state's desire to provide information for people to make choices in life, but it's requiring the decision to be delayed for 72 hours, which can, there's evidence that it can cause a burden when that occurs. So doesn't our analysis has to not focus on where the trial court did, but focus on, is delaying the decision 72 hours going to achieve the state's objective?
Well, I think it may. I don't think we have to prove that it does, but I think your characterization of the...
Where's the evidence that more women are going to decline to follow through with an abortion as a decision, through the decision-making process, by waiting 72 hours?
The Utah study, and Dr. Grossman's own testimony, and Dr. Meadows' own testimony that we have some people who have doubts, and what do? We send them home and tell them to take more time. And so I disagree, Your Honor, respectfully with your characterization that the whole point is delay. I mean, the point of the statute is to provide time, which everybody agreed is a good thing, to make an important decision and make sure certain information was exchanged. The 72 hours is 72 hours. We had an exchange about whether 24 is different than 72. The record shows that as a practical matter, it's no difference at all. It's basically 8 days.
But there's no evidence that the women changed their mind because they had 72 hours to think about it.
Yeah, I think there is. I mean, I don't understand. You're trying to carve this evidence really thin, Your Honor, and I just don't think. I mean, that's certainly one reasonable interpretation from the Utah study. I mean, we have a quote from somebody that says, after thinking about it, I just couldn't go through with it. I mean, I think, you know, does it say that you have to have 72 versus 24? No, Your Honor, but it's almost common sense. Every witness that got on the stand agreed under a good thing, every single person. So the question is it an undue burden? Does it prevent a substantial fraction, if we're talking about the Casey standard, of people from exercising their right to choose? And Judge Farrell said no.
Isn't there, under the balancing test, you got to balance, and for the purpose of this question, whatever the evidence is on consent is what it is. I don't want to, I mean, you've explored that thoroughly with Chief Justice Cady, but whatever the evidence is, it then gets balanced against, as I understand, the Casey type standard, and I'm looking to you to correct me.
I'm going to try.
Yeah, well,
I think you're wrong. I think you're wrong about the balancing test. So Justice Wiggins asked a question about, well, you know, under Casey is the first prong. We've got the statutes designed to protect life versus the health of the women prong A, prong B. You know, is prong one essentially just a naked rational basis test? And as much as I'd like to say yes it is, I don't think it is. I think it still requires an undue burden, but the undue burden analysis there is different, that it's the it has to prevent a substantial fraction, a significant fraction of women from actually exercising the right to choose. I think Justice Wiggins and this court got it right in Planned Parenthood 1 that the second prong, where the asserted interest is health, the health of the woman. So we look at whole woman's health, we look at, you know, the different types of cases, that there is a balancing component there. It doesn't apply to this case, but you would apply a balancing test to decide whether the interest was, you know, supported and you know, decide which side wins. I would argue two things. Number one is, if you look at balancing for this test, and you decided it applies, I think we still win under a facial challenge for two reasons. Number one, some versus some, right? Because that's really the stand, you know, they have evidence
That's
that
my
some,
pro-
yeah, some people will be denied, and we have evidence that some people will change their mind. So Gonzalez says, in the context of applying a balancing test to a medical provision, the late-term abortion, that in a facial challenge, that uncertainty, medical uncertainty, scientific uncertainty, factual uncertainty, the facial challenge fails. And that's because of the problem with facial challenges, that you don't have as discrete, as simple. So it could be that an individual woman could absolutely prove a violation, but in this facial challenge. So I think
I guess the applied challenge would be, someone goes to the clinic, makes a compelling case that they've thought through all this stuff, and are told, no, you have to wait 72 hours, just to say, we go your way. And that person has to then go to court and get some kind of order. I mean,
I mean, it's clear, at least under the federal scheme, I think in Iowa too, you can do a pre-enforcement as applied challenge, right? It's just that you're narrowing the plaintiff attack. Frankly, Planned Parenthood kind of tried this as an as-applied challenge, but they did it for a bunch of different subsets that didn't really prove an individual case, and then they're lumping it into a facial challenge. But a good example, a lot of evidence about women in rural Iowa that live more than 50 miles away from any clinic. I mean, you could frame a as-applied challenge for that that's specific to those people that then plays into this undue burden analysis. They didn't do it. They didn't even try. The other great exception, again, looking at Gonzalez, is exceptions are perfect for applied challenges. That if there's a concern about the scope of the medical exception, that the U.S. Supreme Court has said that is appropriate for a as applied challenge. And that's really why this facial challenge rule matters. I mean, there's a lot of evidence, but there's no evidence about the person for whom 2 trips is absolutely no problem. And we also have, you know, other issues lurking through here, but the context of rural Iowa and the different facts that came in about the access to services aren't on the face of the statute and could apply differently to different people, which is why—
Counsel, I'd like to just briefly take you back to this notion of a substantial fraction of women who might be unable to obtain an abortion. What's the state's view with respect to the definition of a substantial fraction?
Well, we think, I mean, the case law has said, you know, 8, 9, 12% isn't enough. This court would have to decide. I think that it's certainly, I would say that's getting close, to be frank. But when you look at what substantial fraction applies to, it's not, and Casey deals with very specifically, that says a particular burden is not the same thing as an undue burden. And so that if 15% of the people, well, let's use the numbers, you know, if 17% of the people who may seek an abortion live more than 50 miles away from a clinic, that, you know, 17% close call, but that's not the test. Not that it's going to be harder. How many of those people will be prevented from exercising their right to choose an abortion? Going to be much smaller. So I think you have to make the choice. I don't think any of the evidence in this case gets close to a substantial fraction of women being denied the opportunity to make the choice, because in no case are they being denied the choice. That's the trick here. And it, again, in 2 things, I guess, and then I'll try to wrap up because I'm over too, is that in constitutional decision-making, fundamental rights, all this analysis, you have said over and over again that you have to be specific about the right that's being asserted here. And here, you know, it's not the right to abortion on demand or the right to make a decision unfettered by government interference, which Planned Parenthood would like you to adopt. Nobody has adopted that standard. And if you look at Casey, they acknowledge the importance of the state interest, that the government has a right, if not a duty, to take action to try and make sure that's an informed decision. And so, in summing up, unless there's no further questions, I just want to take a minute to say that this court has taken seriously its constitutional duty to interpret and apply the Iowa Constitution. That's why we're here. This case is another step in that important and often difficult duty that you have. In deciding this case, you should adhere to the principles that have guided you to this point. Should not accept their invitation to change. You adopted the undue burden analysis in Planned Parenthood 1. It is a compromise standard. It is a easier standard than your jurisprudence would apply to a facial challenge for something that isn't a fundamental right. If you do that, if you apply your principles that you have applied that brought you here today, you will uphold and affirm the thoughtful opinion of the district court. Thank you.
Mr. Thompson, thank you as well. Ms. Clapman.
As my colleague pointed out, the witnesses at trial testified that some women are not certain of their decision when they come to the clinic, and so they're encouraged to take more time. The evidence at trial was that that is less than 10%, and that those women make the decision with their provider that they should take more time. The state would impose that same requirement on all of the women who come into the clinic, even though the vast majority of them are 100% certain in their decision. There's an obvious difference there. I also want to respond to the suggestion that the evidence at trial was hypothetical. It was not hypothetical. These are studies of real burdens that women have suffered in other states. There was real evidence about the characteristics of women seeking an abortion in Iowa and the obstacles they face. There was evidence from Mr. Reynolds about the real effects on women in the few hours this act went into effect, and I would encourage this court to look closely at the real effects this act had on women on the day it went into effect, and that's in Mr. Reynolds' report, which is in the record.
How about the issue of facial challenge? Mr. Thompson suggests that this case isn't queued up properly, that we don't have a specific challenger with a specific set of facts, and that ordinarily we shouldn't engage in striking down an entire statute and all of its applications absent that.
So that argument fails if the standard is strict scrutiny, because under strict scrutiny, a law is invalid if it is over-inclusive, which by definition means it might conceivably have some valid applications, but it has invalid applications, and that's why it's unconstitutional. Sure. So under the balancing test, this sort of series of as-applied challenges that Respondent is suggesting is not how cases are brought under the undue burden standard. Case after case, Whole Woman's Health, Van Hollen, Schimmel, Humble, a number of the district court decisions we've pointed this court to, including a decision striking down an 18-hour waiting period law recently in Indiana, all of those acknowledge that different women and different groups of women are going to be burdened in different ways, and that this is a context-specific test that has to take those into account and balance those against whatever asserted benefit the act provides. There's no court that requires plaintiffs to bring a series of as-applied challenges to every category of women affected. It would have to be low-income women, domestic violence victims, women who live far from a clinic, women with fetal anomaly diagnoses. I mean, that's simply not the standard under federal law. I also think that the state, with its facial challenge argument, is proposing us a reading of strict scrutiny and a form of strict scrutiny that would actually be less protective than the federal undue burden standard, which just simply doesn't make sense. By requiring that plaintiffs would show that this law is invalid as applied to every single patient. The district court's findings of fact that the act would not prevent patients from having an abortion and that it might change some patients' minds. Respondent said that those findings of fact are entitled to deference. They're not, because they're general findings of fact. They're constitutional facts, and so this court reviews those de novo. And as we've set forth in our brief, there is no evidence to support those conclusions. There was significant evidence that the act will prevent some women from having an abortion. There was the unrebutted expert testimony of 6 qualified experts opining that the act will prevent some women, highlighting populations that would be more likely to be prevented, specifically low-income women, rural women, domestic violence victims, women with fetal anomaly diagnoses, and women who, for other reasons, are close to the 20-week cutoff point. There was evidence of declines in abortion rates in other states after waiting period laws go into effect. There was evidence that forcing women to travel additional distances also prevents some women from accessing
Counsel,
abortion.
you're relying on the 20-week cutoff point. Do you concede that that is a constitutional restriction?
We do not, Your Honor, because it's a pre-viability restriction. We are not challenging it here.
Would Planned Parenthood rearrange schedules to, if a woman were up against that deadline, to accommodate a surgical abortion?
The testimony at trial was that Planned Parenthood tries to do that and is able to do so in some circumstances, but if the act went into effect and Planned Parenthood was having to schedule an additional appointment for every single abortion patient, that would be impossible to do in every case.
Do you acknowledge the possibility that some women are under pressure from perhaps their boyfriend, the boyfriend's family, and are on the fence, and that they might change their mind with additional information and the waiting period?
I would acknowledge that some women may be under pressure from others, both to have an abortion or not to have an abortion, and that the patient counseling process that they go through at the clinic, which screens for coercion, including, counseling patients separately from their partners. It's designed to protect against that possibility. And some women at the end of that process may need additional time to make their decision. The evidence was it's less than 10%, and it's not, and those women are given that additional time. They reschedule. So the act doesn't help them, and it places immense burdens on the other 92% of women. Not only did the district court's fact-finding that women wouldn't be prevented, not only was that unsupported by the record, and it is subject to de novo review at any rate, similarly, the district court's finding that some women will change their mind as a result of this act was not supported by the record at all. And we've had some discussion about that, but I would also point this court to the research that Dr. Grossman cited from Texas, showing identical certainty rates among patients before and after that state's mandatory ultrasound and delay law went into effect. Justice Hecht, you had some questions for Respondent about the substantial fraction analysis that they're proposing under the undue burden standard. And I think this court didn't require some magical number of women be prevented in Planned Parenthood 1, and that's not the proper standard. That's not how courts have looked at this in, Humble, all of the case law that we've cited this court to. And I think one of the things that's most instructive is the way that the Supreme Court looked at this in Whole Woman's Health recently, where the district court made a finding that a significant but ultimately unknowable percentage of women will find their access to abortion reduced or eliminated by the law. And the Supreme Court held that that was sufficient. So certainly the standard cannot be any higher than that. Unless there are any further questions, I will. For these reasons and for the reasons set forth at greater length in our brief, petitioners urge this court to invalidate the act under the Iowa Constitution. Thank you.
Ms. Clapman, thank you as well. And Mr. Thompson, thank you again. And Mr. Thompson, I think you said it very well, that it's a very difficult responsibility courts have. We appreciate that. The case is now then submitted to the court and will sit in recess to transition into the next case.